their winning ways next week. Now, last week we spoke to Barry, who was worried about signing over some assets on behalf of someone he has power of attorney for. With an ageing population, it's no surprise, is it, that more of us are needing to consider having a lasting power of attorney. But what does that actually mean? We wanted to give you all the information about this, so we're joined by Susan Sorrie, who's senior lawyer in the Will, Family and Wealth Department at Shoosmiths. She's based in Northampton. Hi, Susan.
Hello.
So what is power of attorney?
Power of attorney is a document whereby you give power to somebody to look after your affairs, normally at a time when you're unable to do so yourself.
And do you have to decide to do that, or can somebody decide to do it on your behalf?
Well, you're the only one that can decide to do that. The law tightened up a few years ago in 2007 because there had been so much abuse under the old style enduring powers of attorney. So we now have lasting powers of attorney. So the rules are much stricter. You have to have full capacity to be able to appoint an attorney, somebody who's going to sort of manage normally your financial and property affairs when you're not able to do so through mental or physical illness. If you don't appoint somebody under a power of attorney, then what's known as the Court of Protection will appoint somebody to be a deputy. That's sort of the person who's then given authority by the court to look after your affairs, pay all your bills, etc.
Right, because I was going to ask you about that, because very often when you need this to be in place, you're perhaps not at full capacity.
Exactly, and if you're not at full capacity, it doesn't get done, full stop. So we sort of, and most other solicitors, I'm sure, urge people, when they get sort of perhaps into their sort of 50s, if they haven't already done so, to start, if they're going to review their will and they're going to make a new will, then make a lasting power of attorney at the same time.
Right, so you can you put this in place before you need it to be there?
Well, you have to, because if you wait until it's needed, it's too late, and then it's a matter for the court to appoint somebody, and a deputyship application at the present time to the Court of Protection's going to take about 6 months. It's going to cost anywhere between £2,000 and £3,000, and it causes huge distress to sort of family members. You can't pay any bills, you can't do anything. But if the person concerned has put in place a power of attorney, then it's just a case of, obtaining the power of attorney and then acting upon it.
So if you've put this in place beforehand, say in your 50s or whatever, does it just kind of click in when it needs to?
Yeah, it has to be registered. One of the new safeguards are that it has to be registered in what's called the Office of the Public Guardian. That's the administrative arm of the court. And then once it's registered, it can be used. The registration process alone takes about 14 weeks. So again, the advice I would give is that if you're going to do a power of attorney, then have it registered at the same time. It's then stored. It's an insurance policy for the future, and we, along with most other law firms, would only release it on a letter from a doctor to say that the client has lost a capacity, or written authority from the person themselves to hand it over.
Okay, and if you are the person who has been given the power of attorney, or attorney rather, what does that mean?
It means that you have authority to do whatever that person themselves would do. You can sell their house, you can change bank accounts, you can sell shares, but you must always use that money to benefit the person concerned. Right,
that was what I was going to ask you, because we hear from a lot of people who are very worried about it. And
absolutely.
I guess because it kind of takes away your independence, doesn't it?
It does, and it's a huge thing, and I think the older you are, the harder it is to give that up. I mean, when you're sort of perhaps in your 50s, 60s, you understand, you've got elderly parents yourself, you've been there, you can see the necessity of having it. But the older you get, the harder I think it is to come to terms with it and to give up that independence.
And you kind of hinted at it earlier, because it did used to have a really bad reputation.
It did. There was what the government quaintly calls elder abuse, was rife under the old style enduring powers of attorney. As long as it was signed, it didn't necessarily have to be registered. And there were lots of cases, a number of cases I've dealt with, where people have come and they've literally emptied bank accounts. So it's so much stricter now. You have to have what's called a certificate provider. That's a person, normally a lawyer or a doctor, who sees you on your own. They sign a declaration to say that you're not being coerced, so you haven't got your son or daughter standing with a gun to your head. You know, you're on your own, and that you have got capacity. So there are lots of steps in place now for protection. It'd be unfair to say that there's still not some abuse, because there is, but it's a much more serious offence now as well if you sort of empty a bank account of somebody and use the money for yourself.
And to be given power of attorney for somebody, do you have to be related to them?
No, it can be anybody. It can be a close friend, it can be a solicitor. We often act here as attorneys for people. It can be anybody you like, as long as you're not bankrupt or in prison, and as long as you're over the age of 18.
And if you decided that you wanted to, because I'm being entirely selfish here, Susan, and thinking I've got no dependents, so as I got older, if I wanted a solicitor to act on my behalf, would that cost me money?
It does cost money for the solicitor to manage the affairs, but sometimes for sort of people who, as you say, they don't have any dependents, then sometimes it's the answer. It's better to appoint perhaps somebody that you've met or a firm that you've got confidence in than leave it until it's too late and the court will appoint somebody that you've never met, or some faceless lawyer that you've never seen or know.
And is there ever a time where it's not appropriate to have it?
Not really, no. I mean, I think really, the advice has to be the same as everybody should have a will, then everybody should have an enduring power of attorney as well.
It's kind of the sort of thing that you could come and do at the same time as your will, isn't it?
I mean, that's the ideal time to do it. And some firms will offer, sort of a financial incentive if you do the two together. You'll get it slightly cheaper. It is a lot more expensive than it was under the old style enduring powers of attorney, because the forms went from, I think, 4 to 26 pages at one point. And they are horrible. They are an absolute nightmare to fill out. But it's all done as the means of protection and to stop abuse and theft.
There will be people now wondering how much it's going to cost them to do it. What sort of range are we talking?
If it's a couple, and I'd be the first to say, and I know age concern, or we're always saying, oh God, it's so expensive, and it is. But for a couple to have enduring powers of attorney put in place for the solicitor to be the certificate provider, to sign the declaration, and to register it as well, they are looking at anywhere probably between about £700 and £900, depending on the firm.
It is an awful lot of money, but it
is a lot of money.
But it could stop all sorts of problems happening in the future.
It does, and the alternative is that you don't appoint anybody, and you're looking at £2,000 to £3,000 each.
Oh, goodness me!
So although it is a lot of money, I think when people see the forms and they realise the level of protection that's now in place, it genuinely is money well spent.
We also heard from Barry about this possible intentional deprivation of assets.
Yes.
I have no idea what that means.
Well, what it means is a deliberate deprivation of an asset is where you deliberately deprive yourself of an asset, be it money in a bank account or more likely property, in order to avoid paying a debt.
Right.
So you owe me £1,000, but you give that £1,000 away, so you say to me, well, I haven't got the £1,000, I can't pay you it anymore. So you've deliberately deprived yourself of that asset.
I see. So, and people, I guess there are restrictions to that, but I could see a point where somebody might sign their assets over to somebody else to stop them having to pay for care, for instance. They
do, and they do it all the time. And you can genuinely understand why. But it is a deliberate deprivation of an asset, and the rules and government regulations are tightening up. We've got an increasing elderly population. The care of looking after an increasing elderly population is increasing, and the money has to come from somewhere. So people start to deprive themselves of assets, particularly houses. The government starts to look at it more closely.
Are there restrictions on that then?
There are. I mean, a deliberate deprivation is a deliberate deprivation, full stop. So if you give your house to your children but continue to live in it, so you give the house to the children, you continue to live in it, you go into care and you say, well, the house isn't mine, it belongs to my children. Technically, the county, whoever's looking after you, could apply to overturn that transfer. In real terms, at the moment, it doesn't happen as long as it's been done for about sort of 6 months, but we would never recommend anybody to simply transfer a house into their children's name and then stay living there. Not only is it technically a deprivation of an asset, if the children are divorced, if they become bankrupt, the house is theirs and you will then lose your home, because the trustee in bankruptcy really isn't going to care that your 78-year-old mum is living in a house that was once hers.
Yeah.
So it's something that you have to think about very, very seriously.
And there appear to be companies that are offering to take people's assets off them for a certain amount of money. This is how we came to this in the first place.
I know. I think anybody that is approached by, a company, sort of financial services company, a will writing company, anything like that, really does need to see a solicitor, because the costs involved are sometimes astronomical.
Well, the particular example I'm thinking of is £3,000.
Yeah, which is a lot. I mean, there's no reason that you cannot have an asset protection trust. They're perfectly legal. You can put whatever you want into it. The danger is that it may not work. And if you want, here for example, if you wanted to put your property into a home protection trust and an asset protection trust, we'd probably charge you about £850 plus VAT. You'd then have the necessary conveyancing fees for the transfer of the property. So you're probably looking at half of £3,000. But there would be lots and lots of caveats, that there would be absolutely no guarantee that this will work.
The thing that worries me about these companies is, from what I've seen, is you're signing your assets away to somebody that you've never met. Do they own your bungalow then?
Well, it depends, because there are various types of schemes around, and sometimes it's a loan back scheme, which I think you'll find HM Revenue and Customs are investigating at the moment, those types of schemes. Then there are schemes where you sort of transfer the house to a trust company and you then live in it rent free. But there are various schemes, and the majority probably are not going to work.
And just quickly, Hilda in Corby's given us a ring, Susan. She says, if you have power of attorney, but the solicitor remains the trustee, what does that mean?
Well, a trustee and an attorney are two different things. If you have a power of attorney, I think she may have got that slightly wrong. If you've got a power of attorney and the person who has given you the power of attorney dies, and the solicitor is then the executor and the trustee, then they take over. A power of attorney ceases automatically to take effect on death.
Okay, I think that probably answers the question.
Yeah.
Susan, it's been fascinating to talk to you. Thank you very much.
My pleasure.
Susan Sorrie, who is senior lawyer at Shoosmiths. Thank you very much for all your texts and calls this afternoon. It's been lovely.